Hi guys, let's talk about 3 common misconceptions in California about California law in divorce. Number 1, if he cheats, I can get more alimony or more money in divorce. California is a no-fault divorce state. What it means is that when someone files for divorce, they check off irreconcilable differences on a form FL100 as one of the grounds for divorce. There is no box for anything else for divorce except for annulment. We have fraud, we have many things. But for divorce, you don't have any reason, you don't have to have any reason, you just don't get along. So therefore, if your spouse cheats, it has no consequence on spousal support, on division of assets. The only time it matters if the cheating spouse is spending money, community money, on the affair, then the other spouse can ask, may ask, should ask for reimbursement of community funds that were spent on the affair. That's all. Misconception number 2. If we have 50-50 custody, I don't have to pay child support. That's incorrect. Why? Because the child support is contained with 2 requirements. Number 1 is the percentage of visitation. So, for example, you have joint legal, joint physical custody, or someone has sole physical custody, the child resides with one parent, and then you have joint legal custody, means you can make major decisions together about the child's life. Yet, let's say one parent makes $500,000 and the other parent makes $100,000. Then the parent who makes more money most likely is going to pay child support unless the parent who makes more money has 100% visitation in custody of the child, meaning the most amount of time where the child spends, the other parent, the non-custodial parent, has to pay for it because raising child is expensive, especially in California. And right now, the courts use in California, in San Francisco, a software called X-Spouse. It changed from DISAGREEMEnt calculator. If you don't have, or you don't have to buy this software, you can go to the website where Child Support Services calculates child support and just type in Child Support Calculator California, and the first page that ends with GOV, that's the government website, you click and then calculate child support. And then you have to enter the percentage of visitation. If you don't know the percentage, you click advanced, and then you see what options you have. Every other weekend, 14% or 20%, depending when the weekend starts, Friday or Saturday. Basically, you go through that and figure out the percentage, and then you enter gross W-2 income monthly. So you take the W-2, divide by 12, add that in each column for each parent, and then you click calculate, and then you will know what child support is going to be.
I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format.
Child support is only designed for the child living expenses, shelter, food, things like that. Anything else, extracurricular activities, everything else is going to be split 50-50. For example, mandatory child care expenses such as out-of-pocket medical or visitation expenses to meet the child if parents live a little bit farther away from each other, and daycare expenses that are considered expenses so that the parent who has the custody is able to work or find a job. Those are mandatory expenses that are mandatory because the court must split it 50-50. Everything else, for example, extracurricular, if the parents have joint legal custody, they can agree, disagree, and then worst case, the court will decide if this activity is reasonable so that both parents have to split it. I'm smiling because I had a case where we were in court over swimming lessons, and we spent more money on attorney's fees than the actual cost of the swimming lessons. So it's much better to figure out a way to resolve this case amicably, especially extracurricular activity expenses. So debunked misconception is that no, even though you have 50-50 custody and even visitation. It doesn't mean no child support is owed, only if you make equal amount of money and you have 50-50 custody and visitation, then no child support is owed. And finally, the last myth that people have is that everything in California is split 50-50. That is incorrect. So, for example, inheritance is not split 50-50. If someone inherited money during the marriage, that's not split at all. The person who received it keeps it. Gift from parents or third parties, also excluded from 50-50. Money that was there before marriage, also excluded from 50-50. So anything earned or received or anything before date of marriage is 100% separate property of the person who owns it. Then increase in value of that separate property is also 100%. So for example, if someone had $100,000 and invested into some stock, and that stock went through the roof, that's separate property of the person who invested in that stock. Now, there are some exceptions. If someone who invested into stock trades on a daily basis and reinvests the money, then community could have some interest for the effort that the spouse puts into investing, into day trading. But typically, it's 100%. And the same thing applies after date of separation. After date of separation, unless we're talking about venture capital carry interest that is based on the contract signed, I'm not talking about complicated stuff. I'm talking about, pure W-2 income that is based on personal efforts that were created after the date of separation. That's separate property of the spouse who earns that money. So, yeah, technically, practically, the misconception is that we don't split 50-50 everything. We split only 50-50 what was acquired or earned through personal efforts during the marriage. And during the marriage is defined between date of marriage to date of separation. I hope that was helpful, and I will see you soon. Bye!